Good morning, Your Honor, and members of the panel. My name is Howard Slumka. I represent Virginia Hammond in this appeal. And yes, I would like to reserve 4 minutes.
4 minutes?
Yes.
You got it.
Your Honor, we're here in a case that was tried below in a court of equity, but I don't know that equity was accomplished or served. And I'd like you to keep in mind at all times about the results of this case, where we are today and where we were when we began. We had 5 tenants in common who all owned land and were liable on a note. We now have my client, a former tenant in common, who has lost her position in the land and owes a $14 million judgment on a note that used to be roughly half that amount, Your Honor. I'm going to run down my 5 appealable issues in order. I believe the last 4 of them essentially tie together on that theme of equity. The first one is a bit different, and I'm going to handle that one first. You've read the briefs. You understand that Judge Babb, in the first trial, there was a motion to recuse filed on behalf of my client, and that motion was granted. But looking back, it was granted improperly. Consent, even consent, unanimous consent by all parties, does not and cannot cure a legally ineffective order.
But did you challenge that order of recusal on appeal in that case?
Your Honor, fair question. It's the same case. The case number was never changed. Judge Babb...
So I guess your answer is no.
That's right. This is the first time that order has been challenged.
Then here's my question. How is that before Judge Burgess? How is that issue properly before Judge Burgess? Because here's the point. Your client sought the recusal of a judge. For the life of me, we can't understand how this dinner worked out, because it's not, can't tell from the record, but nonetheless there was a dinner. So it seems like she appropriately recused herself.
Right.
So you sought a trial with a presumably unbiased judge, and it appears from the record that you received that.
Okay.
So how is Judge Babb's partial recusal properly before the trial court and, moreover, properly in front of us?
Because all orders under Florida Rule of Judicial Administration 2.330 and 9160, all orders that followed that recusal would be null and void. Essentially, the whole trial before Judge Burgess was an ultra-virus order. And I would argue, and I want your honors to understand, that the second trial was flawed because it had a single co-defendant instead of the 2 co-defendants. And I believe we were prejudiced because rather than standing before the judge with a totally different type of defendant who was the victim of the same type of fraud and breach that we were alleging, we were the only ones there. And I think it did create a different trial, Your Honor. And I understand your question about, well, is that before Judge Burgess or isn't? Because the case number is the same, the case is the same, Judge Burgess didn't really have jurisdiction to try that case, because when Judge Babb, what happened when Judge Babb was presented with the recusal order, frankly, she felt terrible. She apologized. She said, you know, it was a misjudgment and I shouldn't have done it. She then followed that up, Your Honor, by trying to fix it, by saying, let's do the best we can with what we've got. And when she did that, she overstepped. The rules of judicial administration don't allow a judge to cut and paste.
Well, except I'm troubled with your use of the word jurisdiction, because Judge Burgess, like any circuit judge in that circuit, had both subject matter and in personam jurisdiction over that case. So you don't mean jurisdiction, do you? I don't think that's what you really mean.
A fair question. The reason why I chose the word jurisdiction, and I chose it relatively carefully there are some things that cannot be waived and cannot be consented to, right? If all the parties in a litigation consent to subject matter jurisdiction, that doesn't mean the court can try the case. And I would argue we have a similar matter here. It's a very unusual fact pattern. We have a judge...
Highly unusual.
We have a judge who was recused and who stepped back.
But who was recused on your client's motion, right?
That's correct. My client's motion did not ask for a bifurcated trial. My client's motion recognized that something untoward had happened. And again, and the reason why it was so significant is we were alleging fraud and unconscionable acts by these people. One of them was still sitting in the witness box when this dinner took place.
But at the time the judge granted this very unusual partial recusal, which I personally have never seen in 34 years as a member of the Florida Bar. It's a new one on me. But it happened, and I don't recall that your client objected to it initially. I mean, after the fact, your client sought to sort of be re-included back into the group, but initially I don't recall that your client objected to it. Am I correct on that?
We didn't propose it. I believe the concept of whether or not it would be bifurcated originated from both the judge and from Millennium, who wanted to go forward. But Millennium, I think with a lot of foresight, said, we're only going to do this if everybody agrees to do it. And in 34 years, I think the reason why you've never seen this, and this is the crux of my argument, it can't be done. What happened that morning in Dade City can't happen. There is no statute, there is no rule of judicial administration that allows a judge to say, I recuse myself from you, but not from you.
But see, I'm troubled by the preservation of the error and whether or not you've waived it. Now, you've made an argument that said that you can't stipulate and therefore you can't probably waive. It probably follows from that. But show me where it was preserved, where the error was preserved in this case. And I guess if not, is your argument then fundamental error?
Yes, Your Honor.
Okay, well, how is it fundamental? Because she did get a trial before a fair and impartial judge. She was heard, she had an opportunity to be heard, and a judgment was rendered, which she obviously doesn't like, which is why you're here. But I have a hard time seeing how it's fundamental, and I don't see how it was preserved. So help me with that, because we have to get through those hurdles to sort of accept your argument, or at least embrace your argument.
Okay, understood. I believe it's fundamental because we were alleging various breaches and acts by both the plaintiff and co-defendants who are aligned. And we wear, unfortunately, the hat of the angry and bitter ex-spouse. And I think that when we try that case as both the ex-spouse and the wealthy doctor from Georgia who's also a co-investor, I think it very definitely shows that this was not just someone out to get the ex-spouse. These were tenants in common acting the way tenants in common are not allowed to act in Florida. And I think that we were prejudiced. It was a very different trial the second time. It felt like I was trying to defend the bitter, and even the counsel table. You know, at the prior trial, it was a trial about how tenants in common act in the aggregate against other tenants in common. It lost that character because we were standing alone, essentially. And again, my client, of course, wasn't able to be at the table with me for reasons that I'll go into. But I believe it was a fundamental error because the co-defendants color the entire argument. It shows that what the plaintiff did wasn't just a personal attack against my client, but a scheme that was designed to accomplish effectively what they've gotten through the judgment.
Can I ask you a question?
Yes.
What were the previous orders, if any, that BAB had entered that you were aggrieved with? And did you file any sort of motion to vacate those previous orders that predated her recusal?
No such orders were filed to vacate.
Your only complaint is from the recusal forward?
Yes, Your Honor.
The partial recusal. That's your complaint, correct?
Yes, Your Honor. When she recused herself, she had to recuse herself from the entire action.
That's your position?
Yes.
And why was not a petition for certiorari filed at that point? That's ordinarily the remedy on a denial of a recusal.
The recusal wasn't denied. It was
granted in
effectively
part.
it was granted in part, which in retrospect is something that can't happen.
But you later moved for reconsideration of that, correct?
No, sir.
Well, at some point, and maybe I'm describing it incorrectly, but at some point, subsequent to the partial recusal, there was an effort by your client to be reunited with the group. Was there not? Am I mistaken about that? Wasn't there a motion for reconsideration or something filed that sort of said, gee, we've changed our mind, we'd like to be back in the fold? Perhaps I'm remembering it incorrectly,
No,
but I thought there was some effort to...
That came from the other side. Muhanna, Dr. Muhanna filed an action,
I see.
but
Okay.
after we were
It was
effectively
not your
split.
client.
it
Your
was not.
client never... Okay, well, that being the case then, see, I was giving you some benefit of preservation by virtue of that. That being the case then, your client never complained below about the partial recusal and the being sent to another judge? It's only for the first time on appeal this is coming up?
I believe that's correct, Your Honor.
Okay, so there was no preservation below at all, okay.
Again, and I would argue that
Okay,
something is fundamental.
So then your only argument is fundamental error?
Yes, Your Honor.
Okay.
If I could move forward to the other equitable arguments.
Your time is evaporating.
Okay.
I'm
How much
sorry,
time-
this is the
how much
most
time do I have
troublesome
left?
issue.
You got 9 minutes.
Okay.
Probably give you an extra minute if
With-
you need it on the tail.
With regard to the partition claim, partition was always argued, we had co-counsel in the first case. Partition is an equitable remedy. It's really the perfect remedy. Partition and constructive trust and equitable lien sort of go together. It's what the court needs to do when one...
But you never really brought that forward. You made an Ortenis
Um,
motion for it way into the ballgame.
If I could, it was...
Okay, all right, go ahead.
On an October 22nd, 2013 hearing, this was in judges' chambers before trial, I brought it up on behalf of my client. I pointed out that with regard to the pretrial order, there is a motion for partition. We've been dealing with it, as co-counsel with the co-defendant. It really looks like it is his claim, not mine. But as tenants in common, if you partition to one, you partition to all. Judge Babb, on the record, acknowledged that and essentially said, yes, it's before me. If I hear it for one, I hear it for all of you. And then she threw in, and if he gets settled, I'll let you bring it anyway.
But that's an order,
that's
an order by the same judge that you got recused.
That's correct.
How does that carry over and still remain valid before Judge Burgess without a refiling? Because it never really was filed.
No, I understand.
And plus, Judge Burgess, I believe, in one of the hearings says, I prefer you file it.
Yeah,
And it never was filed. So then we don't have any mention of a partition until we have an Ortenis motion during trial.
Federal Rule of Administrative Procedure, of Appellate Procedure, 9.02F, broadly defines order. So I think that her words were in order, and that order was never reconsidered or vacated, so it carries with us before her. What disturbed me about what Judge Burgess did, and the reason why it is reversible error, is he didn't deny the ability for us to argue partition based on its substance, strictly based on procedure. He said it's not filed, it's not in the claims, so it's not before me.
Well, wasn't there a pretrial order before trial, pretrial order entered, that
Yes.
defined the issues? Did you not make it clear in the pretrial order that one of the issues was partition?
That's correct, Your Honor.
You did or did not?
I did not.
Okay.
It was, but before the trial was raised, I brought that to their attention, and I said there was an understanding and an order in the prior case that partition would follow if the other defendant weren't here. It's another reason why, arguably you want to see why I was prejudiced. We didn't have partition. We would have had partition had the other co-defendant been there. But I believe it was reversible error because he didn't get to the substance whatsoever. He simply said procedurally it's not here. And if you go back on the record,
But was
on
there ever
October
a
22nd
written motion filed with an effort to amend a pleading to show, it seems like this case went on a long time on before this issue was raised, and then it was only raised orally. It wasn't like it was even raised with any normal formality associated with amending a pleading.
Right, and I think if you read the October 22nd transcript, that formality was waived by the prior judge. She recognized that partition for one is partition for all, and your partition claim will go forward. Would it have been clearer had a motion been filed and a motion to amend? I suppose it would have
You have a
been.
written order?
I'm sorry?
Are you appealing a written order? Or are you saying you can appeal a verbal order?
I am, under 9.02F.
Or 9.20F?
Is there anything that happened normally in this case? It's like everything is just so completely unusual, everything.
There are a number of unusual facts. I think that's right, Your Honor. And let me, I can go into that about, with regard to the next arguments. should the continuance have been granted. What happened there, and this is my client, she does have an ADA recognized disability with regard to her mental health, she found herself unable to attend a court because when she was taken to the hospital, she was committed under the Baker Act. It was very hard for me actually even to get to see her in the hospital while I was trying a case single-handedly. You can imagine, I was there after hours, and I kept getting promises from doctors they would meet me, and they never did. But here is why reversible error occurred. I did raise and preserve that my client wants to testify and is unable to. The doctor tells me 30 days should be fine, and she had testified before. There was no argument that she would never be able to testify. She had just testified at the prior trial. But here's what's important. If you read Kingsley's brief, they very eloquently and helpfully laid out all of Judge Burgess's consideration. He carefully considered the issue. He made a good record for your honors, and he said, Exhibit 295 wasn't before them last time. I get it. I hear it. But it's only one of 295 exhibits. The record is now made. We're going to go forward. But that's not what happened at trial.
You're into your rebuttal time, but you can keep going if
Okay.
you like.
Mr. Mills called it the single most important piece of evidence in the entire case. He said that it, quote, it seems to conflict with her prior testimony at trial, totally conflicts with her trial testimony. In other words, Mr. Mills and Zabadia is trying to have it both ways. They said to Judge Burgess, on the one hand, she's already been subject to cross-examination. It's no big deal. It's harmless. Just read it into the transcript. And then he says, aha, we've got her. We are impeaching her with the one exhibit that we didn't have last time, a memo from her, which she was not able to be cross-examined on. And, Your Honor, that exhibit, here's why this is important. That exhibit is the only evidence in the trial that shows that my client might have had unclean hands. And that is why the equitable remedies of equitable lien, of constructive trust, of partition are in here. Well, not partition. I believe that if my client had the opportunity, which the case law is very clear, there's a lot of discretion, but if you're in a hospital bed, the discretion is narrowed a bit more. And if you're in a hospital bed and they are waving in front of you the most important piece of evidence in the whole case written by you that you didn't have a chance to cross-examine on, that is very much harmful and reversible error.
Did you object to the admission of Exhibit 295?
No, it was admitted before my client was not allowed to testify, Your Honor. I'm going to save the rest of my time in rebuttal. Thank you very much.
All right, you got it.
May it please the court, my name is Luis Martinez Montfort. I represent the appellee Kingsley Asset Management LLC, who seeks this court to affirm two judgments entered in its favor by the lower court. One was a judgment on a note, one was a judgment on a foreclosure. And I'd like to jump right into some of the issues, and I start with what both Judge Morris and Judge Sleet raised in regards to, and I'll start with recusal, and I'll take the issues in the same order presented by the appellant. As to recusal, I think the key issue there, and the court is correct, and we raised it in our brief, that issue, the partial recusal was not appealed or relief wasn't sought from the partial recusal at the time it occurred. And I do believe it's a writ of certiorari or a writ of probation under Rule 9.030 that should have been filed by the appellant at that time.
The sole basis for the recusal, as I understand it, is this dinner that occurred that Judge Babb went to, that Ms. Hammond nor her counsel went to. But as I understand that before the dinner was had and Judge Babb went to it, there was some conversation and disclosure and acknowledgement that Ms. Hammond and her counsel wouldn't be there, and it was agreed that was going to be okay. Do I have this right or not?
That is my recollection as well, Your Honor.
Because there is an argument in the brief that that conversation happened 2 days after the dinner. So I'm not, so how did it actually happen?
Your Honor, if I recall correctly from trial, when trial concluded, Judge Babb recommended this restaurant, Pearl on the Grove, I believe it was, out in Dade City, and said she was going to make reservations. And that conversation
Was this during the trial or something?
This was at the conclusion of one of the trial days, Your Honor.
That's what I thought, okay.
Okay. And then there was a discussion had, and she I don't know how it evolved into her joining us for dinner, but she invited all the parties, and all of us were going to dinner. I believe Mr. Slomka said Ms. Hammond wasn't going to go, and he wasn't going to go. And that's the rest of us, Dr. Mohana, his counsel, his paralegals, his business partner, my clients, Mr. Mills's clients, and Mr. Mill, we all attended this big 14, 15-person dinner, and I will tell you, nothing untoward happened at that dinner.
Well, I believe that. The brief, and no one seems to have argued to the contrary, but what's really important to me to understand is, before that dinner, did Judge Babb have an understanding that Ms. Hammond and her counsel could not be there? And do I understand correctly that Ms. Hammond's counsel acknowledged they couldn't be there, because as I recall, they're going to be doing some other preparation, and they acquiesced to the dinner without them being present?
That was both my recollection and my impression of what Judge Babb's
Okay,
opinion
is that
was.
disputed?
I think it might be disputed,
Okay,
Your
I
Honor.
thought
Those-
it was, and I wanted to be sure about that, because,
Yes.
you know,
And-
the whole thing is highly irregular.
It-
It's so irregular, I couldn't believe it when I read it, actually. That's why I want to be sure I have it right.
Sure, in Judge Babb's defense, and I digress here, it is unusual that a judge would have a dinner or social outing with parties during trial. However, I do reference the court that I've been to Inns of Courts or other, and I practice a lot in the bankruptcy court, and I've been to a lot of social gatherings with bankruptcy judges during the course of a pendency of a trial.
Really?
Yeah, I mean, in
This is a
regard to...
culture with which I've escaped me in 34 years.
Your Honor-
I can't even imagine going to dinner with a judge in the middle of a trial.
I don't deny it's an odd situation, but let's take a step back. Does that make the partial recusal invalid? And I don't think it does. And I don't think that the grounds for recusal here, Your Honor, the issue was properly preserved by the appellant. In addition to that, the appellant
But
herself...
nevertheless, the judge recused herself.
Correct.
Partially, which again is a first, I've never ever, I mean, I have to tell you, I'm not even smart enough to even had that thought if someone had raised the motion with me. I wouldn't even have thought about it as a possibility. But it happened in this case. And help me understand what happened when it happened. The judge ruled on the motion, granted a partial recusal. The case was sent to Judge Burgess. Did anybody complain or object at that moment?
No, and that's an important fact, Your Honor. If you go back to the record, you'll see that the partial recusal order came down December 10th, I believe. There was a hearing to reconsider the recusal on December 13th at the same time we appeared for closing arguments. And at that hearing, and this is where I get into the argument that we did in the brief, that the appellant invited the error and can't be heard to complain of the error that the appellant created at the lower level and can't complain of it here now at the appellate level. And on the record, and I go back to the transcript...
Back up, explain to me again exactly how they invited the error. I want to make sure.
And
Okay,
I'll go to
ahead.
that. That's where I'm going to now,
Okay.
Your Honor. At that December 13th hearing, and I go back to the transcript at 1798-99, in the original transcript on December 13th, counsel stated on the record that when this argument was happening and the partial recusal was being discussed, and I believe Mr. Mills was challenging the recusal in total, that it shouldn't have been granted. But counsel came on the record and stated that he had discussed the issue of partial recusal with his client, and she was fine with that. And then he went on the record in the same trial transcript pages and said, we consent to the partial recusal. And then they went a step further and filed a consent and an affidavit by Virginia Hammond, I think on December 17th, shortly thereafter, stating, I consent to the partial recusal, and I consent to Judge Babb entering a decision in favor of the remaining defendants. And so the issue, she created the error, invited the error, sought the recusal, invited the error in consenting to the partial recusal, and now can't appear to complain of it on appeal. Furthermore, and I think Judge Judge Sleet also referenced this, what harm did she suffer from the partial recusal? She got what she asked for. She wanted a new trial in front of a new trial of fact that was impartial and had no prejudices. She got that.
Seemed like she got, but her judgment seemed to be significantly higher than the comparable judgments in the other case.
Exactly, and why was that? If you go back and take a look at the record, and you go back to Judge Babb's ruling from the bench on December 13th, you will see that Judge Babb, when rendering her decision, granted the exact same principal amount of the debt as Judge Burgess, the exact same tax debt as Judge Burgess, the exact same prejudgment interest as Judge Burgess, the exact same settlement claim damage as Judge Burgess. However, the difference is this. Judge Babb, in her oral ruling, stated she was not comfortable with granting default interest, post-default interest, which accrued at the rate of 25%. She held it to the contract interest, which I believe was 7%. I believe that is an improper decision by Judge Babb, and I don't have the case in front of me, but I can pull it for the court.
And that's the difference?
That's the difference.
Okay.
Judge Burgess granted default interest as he was required to do under the common law and as the contract called for, post-default interest. That's the difference between the two different judgments. That's it.
And was that, remind me, the challenge that was made to Judge Burgess's judgment below?
Mm-hmm.
Was there one?
No,
Motion for
there's
new
no-
trial, motion for reconsideration, motion,
No, there was
anything?
no challenge to that. As a matter of fact, on appeal, if you take a look at the situation on appeal, the appellant hasn't contested the validity or enforceability of the judgment of the mortgage documents, hasn't contested the amount awarded on the judgment. Just pointed out there's two different amounts between Mahana and Hammond, but didn't contest that the judge made an error of fact in regards to the amount of the calculation of that judgment, nor did they contest that Kingsley was the owner and holder of the notes. If there are any other questions on recusal, if not, I'd like to move on to another portion of the argument.
How about the continuance issue?
The continuance issue.
Because that's a concern. She was in the hospital, she was incapacitated, and while there is a abuse of discretion and wide latitude for a judge, this
Sure.
one fits in the category where maybe the judge should have worked with her.
Well, I think the judge, and I go back to the court, and Mr. Slomka is right, the court's reasoning was very well detailed in the transcript at 624 through 27, and we cut and pasted it completely in our brief. The court spent a lot of time. This was day 3 of the trial. This is a mid-trial continuance. I believe Kingsley's case had already rested in chief, I believe. And what the court did was try to take in as much evidence as it could. And let's talk about what evidence the court had before it. Now, there was no evidence presented before Judge Burgess as to what was actually happening with Hammond, with the appellant. The appellant was allegedly Baker Act. There's no documents to support that. She allegedly could not testify for at least 30 days, but no doctor came forward, nor any other documents were presented before the judge as to that. The appellant produced no testimony, no documentary evidence, and never produced anything other than argument of counsel to substantiate the issue that she was unavailable for trial and wasn't able to present any evidence as when she would be available to testify at trial, which was an issue Judge Burgess wrestled with.
So once the motion for continuance was made,
Yes.
when did it become clear as to when the plaintiff was unavailable? Was she unavailable first day of trial? Had she been Baker Acted prior to the first day of trial?
That's according to the representations of counsel. Remember, there's no evidence presented in the record as to anything that happened to the appellant, but an argument of counsel and presentation of counsel that right when we commenced, I think he stated at the beginning of the second day of trial that in the afternoon of the first day of trial she was taken to the hospital. She was never physically in the court for trial. I think she was just going to come in to physically testify, and that's it. But I think on the morning of the second day of trial, it was abundantly clear that she was, at least by argument of counsel, that she stated that she was in the hospital. So that issue started brewing either late in the afternoon of the first day of trial or the beginning of the second day of trial, Your Honor. And I would go back on the same point. I'll say that the appellant suffered no actual harm in regards to the denial of her mid-trial continuance. Her previous trial testimony from the November trial was submitted in toto without objection. That had the same legal issues, the same facts, same defenses, and same attorneys presenting her testimony and cross-examining her testimony. The only difference, as counsel referenced, was Exhibit 295, which the court correctly pointed out was admitted into evidence without objection, did not preserve any error as to that. I don't believe that you have any harm suffered by the appellant, and I'd further state that the court was correct in its analysis that Kingsley would suffer great prejudice, the least of which is that it had geared up a second time for a trial based upon the appellant's recusal request that was granted. It had brought in witnesses from across the country, and this request was already on the third day of trial when we were almost closed with evidence. And so in light of all the above, I don't think that you have a palpable abuse of discretion by the judge in denying the mid-trial continuance, which is the standard this court must apply. Now, I don't know where I am in my time, Your Honor, and I apologize. I got straight into this argument.
You've got about 8.5 minutes.
Okay, then I'll briefly address a couple of issues. And I'll address partition briefly because that was discussed by counsel. And a couple of points on partition. The first and foremost is there was a difference here. Judge Burgess did not reconsider a ruling from Judge Vavos argued. Judge Burgess, as this court pointed out, denied an ori tennis motion to amend. That's a 1.190 standard. It's an abuse of discretion standard. And that's the argument they have to carry. And it's clear from the record that appellant was well aware of the fact that they hadn't properly pled partition. They filed a motion for continuance in this case a couple weeks before trial. And in that motion for continuance, one of the grounds they argued in support of the continuance of the March trial was, and I quote, if she were to litigate a separate trial, she being Hammond, a motion for leave of court would be procedurally required from her in order to plead her partition request. Here she is filing a motion for continuing, saying, I need a continuance because I haven't filed my motion for my motion to leave to assert a claim for partition. She's admitting she hasn't properly preserved or asserted a claim for partition.
How long had the matter been pending at that point?
Her original answer and affirmative defenses and counterclaim had been filed 16 months earlier. During that same 16-month time period, Mohana amended his counterclaim twice. One of them was to assert a claim for partition. And let's talk about Mohana's claim for partition, which the appellant is trying to piggyback on. That claim for partition, I go back to the original trial transcript in the first 20 or 30 pages of the original November trial transcript. That original claim for partition by Mohana didn't even name Kingsley as a party defendant. Kingsley was not a party to that partition suit.
So the strategy with partition is because these were tenants in common, she would sort of be excised out of the whole, and the mortgage itself would be prorated against her interests, and therefore her exposure is less. Is that the strategy?
I don't know if that's a strategy or not, Your Honor. I will tell you that regardless of what the strategy is, partition is not a defense of the foreclosure, and we briefed that issue in the brief. Partition doesn't stop a foreclosure itself. Partition is an action that seeks to either divide the property or force a sale of the property if it's indivisible. In this case, it takes and has no rights against the encumbrances against the property. So if you file for partition and you name a mortgagee, which would be my client Kingsley, Kingsley in its counterclaim has the right to say, wait, you're not servicing my debt. Forget your partition. I'm going to prosecute a foreclosure. And that's allowed, and we cite several cases that specifically say that, the Lambert v. Lambert case being one of the later cases.
So they were tenants in common with an undivided interest. In other words, they were tenants in common based on percentages, but the 1,000 acres wasn't, this is your 13%, this is your 20%. Okay.
Correct, Your
And
Honor.
a partition action would have identified a piece of land in that 1,000 acres that she would have gotten, and arguably the mortgage would have been prorated as to that. But
And I'll
who
go a
knows?
step further. The evidence established the partition wouldn't work in breaking up the parcels. The evidence established, and we had an expert testify, that if, in the law, if you have a partition claim and the property will be prejudiced by forcing its breakup, it loses value or prejudice some party's interest, then you can't partition into subparts. You have to sell it as a whole, and that's your partition remedy. We had an expert testify in the trial that specifically stated that the plottage value, the value of the property as a whole, is greater than its value in subparts, and you would lose value. The expert said the value of the property was 7.8. If you subtract that and break it all up, it would be somewhere less than 7.5, even less than that. Either way, it becomes irrelevant because the encumbrances are so much greater than the fair market value of the property, and that partition can't stop foreclosure, that the partition claim,
Yeah, it was
even
about
if asserted-
$13.5 million against like $7.5 million in value. Is that what I remember?
Correct,
Yeah.
correct. And so, stepping away from the fact that partition doesn't stop foreclosure, stepping away from the fact that the partition wouldn't have been broken up, would have been sold as a unit, where do you get at the end of the day? You don't get anywhere because the encumbrances overwhelm the value of the property. And like I stated before, even if the appellant had piggybacked on Mohana's partition claim, it still didn't seek any relief whatsoever against Kingsley. Kingsley wasn't even a party to the partition. They didn't even name Kingsley as a party to the partition. So you would have partitioned the property while the foreclosure was going on, and the foreclosure sale would have happened before any kind of partition would have occurred. So partition isn't an appropriate defense to foreclosure. If any of the judges have any other questions in regards to petition, if not, I'd like to continue on. Briefly, I think I only have a couple minutes. The appellant didn't address these issues, and I'll address them briefly. The first one is they claim that the trial court it made an error in granting foreclosure in the full judgment amount of the debt, and they argued that Kingsley was the alter ego of one or more of the underlying TIC defendants. I think that the court and the record is very clear that the court inherently found that Kingsley was not the alter ego of either the Savati Family Trust or any of the individual defendants, and more than substantial competent evidence was presented. To be clear, that was probably the big factual issue in this trial. There were several days of testimony talking specifically about was Kingsley the alter ego? And to pierce the corporate veil and use the alter ego, you have to show that Kingsley was an entity dominated by a shareholder or a member, in this case, this is an LLC, that it was formed or used for an improper purpose, and that the underlying party was damaged.
Did Exhibit 295, Ms. Hammond's affidavit addressed that key issue?
No, Exhibit 295 had nothing to do with Kingsley being the alter ego or the claim of Kingsley being the alter ego. I believe Exhibit 295 dealt with something addressing an issue in a prior divorce proceeding and whether or not she supported the actions of Shai Shalindra, who was the original bad actor and put these investors together. 295 had no relevancy as to any claims asserted against Kingsley. And so in regards to the alter ego, the evidence was overwhelming before the court, and that's how the court found inherently in its decision was that Kingsley was a pre-existing entity. It wasn't formed for the purpose of buying the loan documents. It was an empty entity that was used for the purpose of acquiring the loan documents. Kingsley followed all the corporate formalities. It had separate accounts, proper documentation, proper reporting, proper separate manager. It treated, and this is an important fact, when Kingsley acquired the note, it treated all the tenant comments the same. So Kingsley's sole member is Sabadia Family Trust. When Kingsley bought the note and pivoted and went to all the tenants in common, it treated them all the same. It demanded either the full obligation or it provided avenues of resolution for each one of these ticks to resolve the joint and several liability for less than the full amount of the obligation. Several of these tenants in common participated. The appellant did not. It's important to note that the single member of Kingsley, the Sabadia Family Trust, as a tenant in common, also participated and paid $1.3 million, I think, for its participating interest in the Kingsley note to resolve its obligations to Kingsley as the lender. So take a step back. Sabadia Family Trust fully funds Kingsley to pay $8.3 million for the bank note. Then Kingsley, as a separate and distinct entity, turns and pivots to all the tenants in common, and now Sabadia Family Trust, on the other side of that coin, has to come forward as a borrower and pay its fair share.
You've got about a minute to wrap up.
Yes, Your Honor. If there's no more questions, or if there's any questions on that issue, if not, I'd like to move on to the last point. I think the court correctly denied appellant's affirmative claim for breach of fiduciary duty. That's also a competent substantial evidence test. Kingsley was not a fiduciary of the tenants in common. Kingsley was a separate and distinct entity. It was not the alter ego. And in regards to the breach of fiduciary duty claim, Kingsley had no fiduciary duty to any of the ticks. If Kingsley did have that, and let's think about that and let's argue that in the alternative, if Kingsley did have an obligation or fiduciary duty to other ticks, did Kingsley fulfill that fiduciary duty? And the answer is yes. The evidence is clear. Kingsley turned and made multiple requests to each and every one of the tenants in common to step forward and pay their proportionate share. If a tenant in common acquires a mortgage position, the other tenants in common who didn't participate in that acquisition have an obligation to step forward and pay their proportionate share for that obligation.
Your time is up. I'm going to give you another 30 seconds to
Sure. These
say
tenants in common,
goodbye.
the appellant never stepped up. Kingsley sent four letters in writing. The record is replete. Kingsley kept asking for her to participate, and she did not. If Kingsley was a tenant in common or had some fiduciary duties, it fulfilled those fiduciary duties, and the court properly denied her fiduciary duty claim. And so, Your Honor, I rest on the point that this court should affirm the lower court's decisions. Thank you.
All right, thank you. Mr. Slomka, since I gave him extra time, I'll give you an extra 30 seconds too.
Do you mind if I ask you a question real quick? Because I just, you, before you start, I just have a question because I'm trying to assess the relative harm in this partition claim that you were not allowed to advance. What was the strategy? Is the strategy to carve out a piece of property and get a pro rata application of the mortgage? In other words, what was the benefit to your client? What was the harm she suffered as a result of not being able to do it?
It's an excellent question, and it goes to this is an indivisible piece of property. So the harm is that equitable lien constructive trust partition, which is a remedy, not a claim. It doesn't need to be pled. All of those remedies would allow a judge to take a tenant in common who was underwater but who hadn't paid her fair share and to divide that fair share so that she didn't suffer a $14 million judgment. She would suffer whatever percentage that she was behind. And that's really what we're seeking here. The equitable lien, the constructive trust, is designed to be fair to all tenants in common. Partition would have done exactly the same thing by selling this land to somebody, and they all would have gotten benefit. Just very quickly with regard to the dinner, because they are very odd facts, the judge said, would you mind if I would make an introduction to you all to friends of mine who own a restaurant? I thought it was a little bit inappropriate, but I said, no, we won't be at the dinner, Your Honor, but I don't mind if you make the introduction. It was some 2 days later that I learned that it wasn't an introduction. that she apparently sat at the
Is
table and...
all of this in our record, or are you telling other things outside?
It's in the record. It's in the
Because I just
record.
want to make sure we
Right.
don't
So she-
inadvertently do that.
Right, so she,
I apologize, I don't know if the record transcript is very clear about those discussions. I believe they were heard
Okay.
right after
Right.
the transcript.
Just make sure, yeah, we only
But-
want to know what's in our record.
but yeah, there was no acquiescence to dining with the other litigants. There was an acquiescence to, I don't mind if you take them to the introduce them to your friends who own a restaurant. That's not what happened. So, and then we very promptly had a sidebar with the judge in a room and said, what happened, 2 nights ago? Okay, with regard to Appeal's claims, Sabadia, he mentioned, fully funded this purchase by Kingsley, and that's an important word. It was Sabadia's funds, and the Adams case, which is cited by both parties, says what tenants in common can and cannot do. And it was a very small piece of property there, but what happened in the Adams case is they took a straw man, and Donald gave him his money and said, you buy the debt. And that's what happened here. Sabadia bought the debt. He bought it through Kingsley, but it was his money. He bought the debt. The reason why I reference that, partnership law does apply to joint ventures. It's in the Holiday Isles case. And partnership law has the highest and finest duties of loyalty. And in every case that we're citing, Your Honor, they cite it for one thing, we cite it for the other. You will not find a single case in Florida law where one tenant in common has put the screws to another tenant in common, and I don't even use that expression. That comes from one of the emails that's on the record in this case. Okay, so it was not proportional. What happened here was the opposite of proportional. And I believe that if the equitable remedies would have been allowed, we would have had a proportional result. We would have had a fair result, an equitable result. And the reason why equity wasn't allowed, I believe, is Exhibit 295.
So what's your remedy? Is your remedy to go back and now have a trial with everyone else who's already had a trial?
Well, no, my remedy is for Mr. Sabadia to get the money back. My client doesn't deserve the land. She didn't have the ability to pay for it. There's an old expression, you can lead a horse to water, you can't make them drink. They tried to say pay up, but she couldn't pay up. The better analogy here is you can lead a horse to a canyon, but you can't make it fly. They knew that she didn't have money. They knew she couldn't pay. The proper remedy here then is to get it together and to say, constructive trust. Sabadia is going to get his money back. You're all going to be made whole in the way that you are. It won't add up to the value, but not...
So what do you want us to do, though?
I want you to acknowledge that the equitable remedies here...
So we send you back to the trial court to do what? That's kind of all we do here.
Right. You send us back. I think we retry this case.
Because,
in-
but retry with everyone who's already had their case tried and has a judgment rendered by Judge Babb? So you're going to make them all retry their case too? Not just your client?
Partition for one leads to a partition for all, Your Honor. So I don't think they would need to be there. I think Muhana,
But
based on...
aren't you here complaining because you only had a trial without everybody else and she did a partial recusal?
Right,
That's why I'm trying to understand your
But I
remedy.
don't need that remedy as a result of all of my claims, Your Honor.
Okay.
Yes, if you grant all of my relief, we try this case with Dr. Muhana next to us, and we seek the equitable remedies that should have been applied under Florida law to begin with.
All right, and you're out of time.
Thank you.
Thank you.
Thank you, gentlemen. Very tough
I
case.
appreciate your
Good
time.
argument.
All right, we're going to move on to the next case. Clausen versus Maslin and Shetler.